Good afternoon, law nerds. We are going to court in Utah today. It is August 8th, 2024. Kouri Richins is back in a Utah courtroom. It's been a minute since we have checked in with Miss Kouri Richins, hasn't it? Yes, it has. For those of you that are like, the who, what now? I found your channel recently and I'm not quite sure who Kouri Richins is. Don't worry, I'm going to give you a bit of a road so far on the T. There's a motions hearing today. Kouri Richins and her attorneys are trying to kick off the DA and the entire DA's office. They're big mad. The DA's office is also big mad. Everybody's big mad. I'm going to remind you of the things that make me big mad. Olympic spoilers. I've been working today so that we're ready for Karen Reed tomorrow, and I haven't gotten to watch anything yet. So I appreciate y'all for riding with me during the 2 weeks every 4 years of sports ball that I actually care about. So thank you. If you do not follow me on Instagram, well, if you're watching this now, you can go see my stories talking about water polo. And that was delayed so that it wouldn't spoil anybody. I gave it like a full day delay before I got caught up on men's water polo. If you want a little bit of information about water polo and what I thought of the game, it's in my stories. It might seem a little out of order because a few of my stories got claimed by the Olympics. And I'm like, this is fair use. All I'm doing is screaming and explaining why I'm so angry and why some of the referees' calls were not great. Members, remind me in our next Members Only Live to tell you how I almost got red carded out of a game as a spectator. We can talk about times I got red carded out of games as a player. I technically never got red carded. I did max out the number of exclusions a player can have a game and get kicked out. But remind me to tell you how I almost got kicked out as a spectator, because that's the way that goes. So We'll share those stories later. Also, if you are in the app, I will be sharing when I have links. I have done some television regarding the Girardi case that is on trial in Los Angeles. I updated it on the podcast. It is going along as expected. I will keep you guys up to date lightly on the Girardi case in the app, in the community tab, but it's a federal case, no stream, no audio, no nothing. Matt Hamilton from the LA Times and others are reporting on it from that federal courtroom. And we are going to go to court in Utah to watch. The court today said no streaming. So I was optimistic about how quickly I would get access to the pool feed. It took a minute. So the pool feeds can be slow, but it just is what it is. I hope the court changes their mind for the preliminary hearing. We will find out what they decide to do, because there will be a 3-day preliminary hearing for this case. Let's roll the intro. Let's do a road so far. For those of you that are like, Kouri Richins, who's that? She was Googling luxury prisons for rich people. We're going to talk about Kouri Richins. We are going to talk about Kouri Richins. But let's roll the intro first, and then we'll chat. We'll do a little road so far, and we'll go to court.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right, y'all, we are going to put on our little live court so that we know what we're doing today. Today is a live court kind of a day. For those of you that are like, Kouri Richins, who, what now? Utah versus Kouri Richins. She is accused of poisoning her husband. She is accused of attempting to poison her husband before he passed from a fentanyl overdose. The bail hearing I covered, and it was illuminating. She got into a fist fight with her sister-in-law over his estate. He, it seemed, had some reservations about where the marriage was going. She seemed to know, based on her text messages, that if they got divorced, then under the prenup, she gets zip and was having some financial struggles, some substantial financial struggles. And if he died while they were married, she took half of his business that he owned with a business partner. So his portion of the business, the house, everything. What she was unaware of is that he had put everything in the name of his sisters, like a trust that his sisters were in charge of. So she did not get the house, the bank account, the vault, not the vault, the vault, I guess. Emily, why can't you think of words? I don't know. The safe. That's the word. She was trying to break into the safe when the sister-in-laws stopped her. So the victim, Eric's sisters, became the executors. There are multiple civil lawsuits going on with regard to the estate of Eric Richins. In the bond hearing, we learned about the substantial financial struggles Kouri Richins was going through, the text message back and forth to purchase the substance that ended up into her husband's Moscow Mule. We saw the walk the dog letter where she said it is a fictional story, but seems to perhaps be open to interpretation of her and her mother and brother trying to get their stories straight. We've heard a number of her jail calls. By heard, I mean we've gotten transcripts of them, not actual audio of them. We have had audio from Kouri Richins because she released a statement to the media because she wanted everyone to know how unfair it is the way she's being portrayed. And so she left like voicemails for a podcast that is connected to Dateline. I'm going to tell you in a second a bit about what she said in that because we haven't gotten to cover that yet. She is charged with 1 count of aggravated murder for the death of her husband, Eric Richins, from March 3rd, 2022. 1 count of possession with intent to distribute a controlled substance. 2 counts of possession with intent to distribute a controlled substance. Mortgage fraud, 2 counts, fraudulent insurance claim, 2 counts, and 3 counts of forgery. So there is a lot that was added on later in the case. Her attorney, Sky Lazaro, left the case, and so she has new attorneys. She's pending preliminary hearing. She's been in custody almost a year now. She wasn't arrested till a little more than a year after the death of her husband. And in the intermediary, she wrote a children's book about how to deal with the grief of losing her husband. She also was, the one that was Googling things like luxury prisons for rich people and Googling how to pass a lie detector test. Can deleted text messages be recovered by police and things like that? The walk the dog letter, because it said walk the dog across the top. There's been much argument over whether this letter was attorney-client privilege communication, which if it is a manuscript, it can't be. But she argued it was attorney-client privilege. Her attorneys argued that it was part of a larger manuscript, that it was fiction. Again, if it's fiction, it's not attorney-client communications. But it seemed like setting up a story with her mom and brother. And it's like, remember. And it seemed that she was doing this on video calls with her mother and holding up the letters because jail calls are recorded. In that letter, she also tried to have her mom smuggle her Crest white strips because she wasn't really happy with how she was looking in her televised court appearances. So this is a very interesting defendant to me. And in the motions that have come out, because the defense will do something and then the prosecution's like, oh yeah, here. And the prosecution keeps adding all of the information that they can into their motions. We've learned that there were also text messages between Kouri Richins and a paramour. So we don't know much about the paramour, but we know that there is insinuation per the prosecution's motions that not only was Kouri Richins having substantial financial difficulties due to overextending herself in real estate, that she was, the prosecution alleges, forging bank statements to take out mortgages on houses to buy new houses. And while all this was going on, she is playing nice with her husband while texting about not really adoring her husband and then also texting her paramour. The first time she attempted to poison her husband, as alleged by the prosecution, was on Valentine's Day. She made him a sandwich to take to work. It made him incredibly ill. He called friends to tell them about it. She subsequently texted and asked for stronger fentanyl. And then he was killed on March 3rd. So from February 14th to March 3rd, there's quite a lot of texting activity, a criminal mastermind. It seems Kouri Richins is not, but what it is a very interesting case. And I was blown away at the bail hearing when her sister-in-law got up and started talking about Kouri Richins, like throat punching her days after Eric Richins died over the safe with his money and weapons and things in it. So the children's book, The Luxury Prisons for Rich People, the paramour of it all, the prosecution has been spilling the tea and the defense is big mad. Here's why. Defense attorneys for Kouri Richins have argued that the entire district attorney's office needs to be removed from the case. They are trying to yeet all of them. Why? They say that the district attorney's office have invaded attorney-client privilege in a number of ways. We read this motion a while ago. This motion was filed the same day. Like a whole bunch of motions were filed by Sky Lazaro and her law firm before she also filed that she was removing herself from the case. I'm surprised it took so long after that walk the dog letter, but whatever. Sky, leaving the case after these motions were filed, leaves the now appointed public defenders to deal with these motions to recuse the entire DA's office. So they're alleging that the district attorney's office invaded the attorney-client relationship by accessing the rest of the walk the dog manuscript and by listening in on attorney-client phone calls. When the district attorney's office responded to that, they said, yo. So there's separate phone lines to call in. If you're an attorney, you can call in and talk to your client using a particular app and going a different way. If you just call in on the public line, you are met with, this call is being recorded. Her attorney was calling in on the public line, this call is being recorded. And when they dump all the public calls to the DA's office, they were going to the DA's office and the DA's were then like, and this marking the calls that were with her attorney once it became apparent that that attorney was the one talking to her, and then not listening to them. And the DA's office was very clear. Look, first, we're not listening to your calls. Okay. Second, if you call in on the public line when there's an attorney line for you, we think you're waiving privilege. That said, we're not pushing the issue because we're not listening to your calls. But we know everything that you're talking about with your client because she's calling everybody else and telling them what you said. So all that we know about the attorney-client communications are from your client telling her mother, her brother, and whoever else. Telling another person, telling your mom, hey, I'm talking to my lawyer. She's a dumb bitch. Yes, that's in the transcripts of the jail calls and blah, 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 blah. It absolutely voids any attorney-client communication, right? You're telling it to a third person. That's not privileged. Kouri telling her mom what her lawyer said is not privileged. Her communications with her lawyer are. So the DA's office was saying lawyer needs to call in on the app. But DA's office also said, hey, lawyer doesn't want to call in on the app because the lawyer thinks that the app is going to track their entire phone or whatever. And we know this because Kouri was telling her mom and brother about that on her other calls. So the DA's office said everything we know about what's going on the defense side is because your client's telling everybody about it, not because we're listening to your calls. The defense was not persuaded by that, but the defense also left the same day. So they're like, hey, Your Honor, the DA's office needs to be recused. Also, we're out of here. So I think it's an interesting argument that the defense attorney calling in on the public line, knowing it's a public line, knowing it's a recorded line, when there is the option to call on a non-recorded line, might be waiving privilege. Is anyone taking up that very interesting legal argument? No. Do I think someone should put that on a law school exam? Yes. I think it's a really interesting question. Does knowing the call's being recorded, does that void attorney-client privilege? interesting, fascinating legal question. Are we here today to ponder all of this together? No, we're here to take a look at what happened in court when this motion came for hearing. The motion is to yeet the entire DA's office. But before we do that, we're going to take a quick look at what Kouri Richins has had to say for herself about the case and in the needing to make a statement to the media, because, well, girl, you have a right to remain silent. And I think maybe the best thing to do is to exercise it, keeping in mind, though, that Kouri Richins has been in custody without bail. She was denied bail based on the nature of the case. And so we're going to go take a look from NBC at what Kouri Richins has had to say. Let me make sure this gets pulled up in reader mode. So let's go take a look at her statements, and then we're going to go to court. It's a pretty quick hearing today, but for those of you new to the case, I think you need to understand the Kouri Richins of Kouri Richins before we get to the rest of it, right? So chat, it's good to see you. Let's talk about the Kouri Richins of it all before we get into the rest of it, because we haven't even gotten a chance to cover this yet, right? So in reader mode, this is coming from NBC News. This means war. Utah grief author, I call her children's book author, but whatever. It's better, I think, than calling it like the Utah mommy murder. It's like the luxury prisons for rich people one is the walk the dog case. This means war, Utah grief author Kouri Richins makes first comments since arrest in husband's fatal poisoning. Kouri Richins, the Utah mother accused of spiking her husband's cocktail with a fatal dose of fentanyl, made her first comments since she was arrested last year in a series of jailhouse statements that criticized prosecutors, asserted her innocence, and described recent upheaval in her case as forced. By you? Who forced it other than you trying to get your lawyer to sneak you in stuff and you telling your family in a letter, like, the defense attorney says, I need this. So can you tell this person to say this? Come on. I thought her lawyer would have been out then. Richins, 34, mother of three, who wrote a children's book about grief after her husband died, made the recorded comments to a spokesperson who provided the audio exclusively to Dateline this week. Richins has been held. What? She has a PR agent? Sure, Jan. Richins has been held in Summit County Jail east of Salt Lake City since a judge denied her bail last year, and I covered the bail hearing. If you're interested in it, that's the one where the sister-in-law talks about the throat punch. Quote, this is the defendant. Quote, I've been silent for a year, locked away from my kids, my family, my life, with the media telling the world who they think I am, what they think I've done, or how they think I've lied, she said in one statement. And it's time to start speaking up. I wonder if the timing of this coincides with her attorney's leaving. No, it's right after her attorney's leave, but this is a difficult defendant. She goes on to say, you took an innocent mom away from her babies, and this means war. Huh. Good God, y'all. What is it? Okay, no. Emily, no. You took an innocent mom away from their babies. Kouri, we watched the bail hearing. The text message asking for stronger fentanyl after he didn't die is a little bit damning. When you look at the evidence in this case, I think how it would be described by many is overwhelming. I think that's how many would describe the evidence in this case as we've seen it so far. It says the comments come after a judge granted her lawyer's request to withdraw from her defense against charges of aggravated murder and other crimes in the death of her husband on March 4th, 2022. The charging document has that as March 3rd, 2022. I'm going with the charging document, not the reporting. Richins' lead attorney, Sky Lazaro, attributed her team's withdrawal request to an irreconcilable and non-waivable situation. Yeah, I bet. In one of the statements, Richins said last week that she was filled with great devastation and added, "My defense team has been forced to withdraw from my case. Represented or not, we all know and should understand there's only so much I can say, but what I will say is the withdrawal was not my choice." Yes, that would have been you firing your lawyers, but maybe don't call her a dumb bitch on your jail calls that's going to end up in the DA's filings. Because I imagine that the attorney was not thrilled with that. I mean, that's after you wrote the walk the dog letter and said Sky needs the fentanyl to have come from somewhere else. So don't forget to tell brother that Eric used to go to Mexico and like get drugs and stuff. So it came from, I think she was trying to say it came from like weed gummies. But that's still not going to undo have Sky sneak me in some Crest White strips. I'm sure your lawyer's not super comfortable with you thinking that she'll just, violate the rules of the prison for you. And Sky like fought tooth and nail for this defendant too. It can't be an easy client, but I also wonder if the civil lawsuits have locked up a bunch of the money. I wonder if that was the ultimate the ultimate at the end. But from early on, Sky was fighting this case at every turn. So it's interesting to see the defendant turn around and name call her in those jail calls. So she said, "My defense team was forced to withdraw from my case, represented or not. We all know and should understand there's only so much I can say." She said, "It was not a personal choice of any counsel on my team." We don't know if that's true, but attorney-client privilege remains and her attorneys can't comment on it one way or the other. So I'm not surprised that the next sentence is Lazaro would not comment. The withdrawal request was filed the day Richins' lawyers asked the judge to disqualify prosecutors over what they described in a filing as, quote, severe violations that compromised their defense and violated Richins' constitutional right to counsel. This is part of the filing that I summarized, but it says from May to December last year, the filing states authorities recorded jail calls between Richins and her lawyers without their consent. What the news doesn't clarify is that jail calls are automatically recorded. And when you call in on the recorded line, they automatically get recorded. It's not like Watergate recordings. It's not surreptitious recording. It's this call is being recorded because her attorney didn't want to call in through the app that allows them not to be recorded. So they say prosecutors had listened to some of them, the filing alleges, which is accurate, until they heard the lawyer identify themselves. And then prosecutors flagged the call and stopped listening, they say. It goes on to say when one of the defense lawyers discovered the practice and asked prosecutors whether they were aware of it, Summit County's top elected prosecutor, Margaret Olson, responded no, according to emails included in the filing. Minutes later, lead prosecutor Brad Bloodworth, yes, the lead prosecutor on the case's name is Brad Bloodworth, wrote that because one of the defense attorneys had refused to use a phone app that shields attorney-client calls, those calls had been recorded and that the lawyer was, quote, well aware of this. Yes, because it says these calls are being recorded. Bloodworth added that prosecutors had not listened to any of the calls when the defense team continued to express concern. Bloodworth responded that by not using the app, the lawyer seemingly consented to the practice of recording the calls, and the defense team had ratified it because it had been happening for 6 months. Prosecutors provided the lawyers with the recorded calls through discovery throughout that time period, Bloodworth said. So they just got the calls on a disk or probably a drive now, like in a, I don't know, whatever kind of drive they use. They probably get them as a digital download and then just forward it along to the defense. Like, these are all your clients' jail calls from this time period, because they download them. And Kouri talks a lot. So I saw the comment in the chat. Runkle said, who listens to those messages anyway? Who, Runkle, who? The DAs, right? Runkle's like, who listens to those pesky jail calls? Everyone. Although I'm extremely disappointed where we're at right now in this case. I'm anxious. I'm anxious to prove my innocence. I'm anxious to get to trial. I'm sure she is, but we haven't had the preliminary hearing yet, and time has been waived. In an email on behalf of Bloodworth's office, Olson, that's the elected DA, said since charges were filed against Richins, her office has deferred to and accommodated the defendant's scheduling preferences and requests. In a statement released Wednesday night, the DA's office said that the defense lawyer's motion to disqualify prosecutors was materially inaccurate and had been filed in bad faith. The statement said that the county attorney's office planned to file a response to the allegations by May 31st, and they did file a substantial motion. We'll go over, because so much court has been happening, we'll go over other transcripts from her jail calls another day, but we'll get there. It goes on to say in a statement, the county attorney's office planned to file the response and address the motion at the appropriate times, which is what we're doing today. Prosecutors allege that Richins was in deep debt and fraudulently obtained a nearly $2 million life insurance policy on her husband before she gave him a Moscow Mule that authorities say was spiked with a lethal dose of fentanyl. Prosecutors charged Richins this year with an additional count of attempted murder, alleging that she drugged her husband's Valentine's Day sandwich in a separate effort to try to kill him. That was the day she was texting her paramour. She sent her husband off to work with a poison sandwich, and then was texting the side piece. She is also charged with forgery and mortgage and insurance fraud. She has not entered a plea. She and her family have maintained her innocence. And that is where we pick up today's hearing. Are you riveted? Are you now riveted? Did we sell why Emily is fascinated with this case well enough? Let me make sure our audio is gained up and we are ready to switch into the video presentation portion of this after I just absolutely messed it up. Hold on. Emily, streaming is dynamic. Don't worry. We're going to be streaming today. We're going to be streaming tomorrow. For those of you that don't have the Lawnard app yet, today is the time. Because, well, tomorrow we're going to be in Massachusetts for court, and we'll see how all of that goes. So let's pull this back up and go into the pre-trial hearing. It's a pretty short hearing. The initial part of the hearing is just them getting things together on the record. So we're going to pull it up and then zoom past all of that because A, we don't need it, and B, we don't need it. I just want to make sure that we can hear it. And all of you that are like, I am enthralled. Yep, this case is one of those cases where I'm just like, tell me everything. I want all of the tea. So let's go ahead and swoop-a-doop and let's head to court. I know, I feel like we should start saying just like snoop-a-doop because that's what it is. All right, so the beginning of this hearing, they come out. I want to make sure we can hear. That doesn't sound like we can hear.
Thank you.
Hold on. That doesn't sound like the audio's in the right spot. So let me fix that real quick. Yep, that's on me. Sorry, chat. Totally my bad. Let's try this again and see if we can hear now. This is why we try more than once. That's better. That sounds better to me. I like this judge a lot. These courtrooms look the same as the ones from the Gwyneth Paltrow case because they're the same.
Miss Lewis? Yeah, I apologize. I don't know why I'm having this problem right now.
You guys said it was echoing, so hold on and let me see why it may be echoing. That's strange. Hold on. Let me see why it's echoing real quick. This has been an ongoing adventure. Apologies, chat. Let me do this one more time. That's why we start and then we start again. Let's do it this way and see if that is better. All right, let's go.
Mr. Ramos, do you need to speak with Ms. Richins before we get started?
The echo was me.
Just one moment.
Yeah, why don't you take the time you need?
And by the way, Ms. Nestor is just had a jury come back in West Jordan, so she's not going to make it. They just came back within the last 5 minutes, so
No problem.
Okay.
to know that she was not ignoring.
If she decides to join by WebEx, there's an audio link available.
Oh, I'll let her know.
Okay, it's the
Okay.
same
So-
link we use all the time.
I
The
will text her
court-
telling her that.
Okay, sounds good.
The court
Take
is
the time you
saying, hey, talk to your client. We're doing this motion. Take the time you need to talk to your client. And the attorney said another attorney is missing because they just got a verdict back in another courtroom. So they can join by WebEx when they have a chance, but they're not joining now. So I really like this judge. We're going to zoom real quick because all they do is allow for the defendant and her attorney to talk, and then they go back on the record. So.
Okay, you do it on the record. Okay.
So, and then he'll call the case when they're ready. I like the judge's voice too. I'm ready for this trial, but we've got a 3-day preliminary hearing before we even get there.
I don't think I know how to get online in here.
I don't think anybody knows how to get online in here.
Okay,
Tethering to your phone is typically the better bet.
all right.
They are in the
I don't know.
same courthouse that the Gwyneth Paltrow case was in. There are not captions. At this point, there might be,
We're good. Ready? Yep.
we might have captions on my end. Hold on, let's see. Oh, nope. They've populated. It took a minute, but they've populated. Hold on. For those of you asking, when does trial start? We don't have a trial date yet. The preliminary hearing is later this month. There we go. So. So that's why the courtroom might look familiar. Let's zoom. Let's call the case, Your Honor. The trial should also be recorded. I don't know how the court's going to handle that. They let the hearing they let all the Gwyneth Paltrow case be streamed. The court said today that the hearing couldn't be streamed, but could be recorded and distributed after court was done. So we're just gonna,
All right.
we're gonna zoom.
Good afternoon. This is case 231500139, the state of Utah versus Kouri Richins. Can I have counsel for the state make their appearance, please?
Margaret Olson and Brad Butler for the state.
Welcome to both you and for Ms. Richins.
Margaret Olson is the elected district attorney. They're with Mr. Bloodworth. These are the new attorneys for Kouri Richins introducing themselves.
Andy Lewis and Mr. Rollins from Ms. Richins, and as I said, Ms. Nestor is held up in court in Salt Lake.
Understood. Good afternoon, Ms. Richins. All right, we're here on a motion to disqualify the prosecution. That's docket 481. Ms. Olson, before I turn to defense counsel, I understand there were a few things you wanted
Yes, Maddie,
to
agreed.
put on the record before we got going.
Yes, Judge, I have 4 items to clarify. The first one is, it's our understanding through counsel that the defendant has waived hearsay objections for purposes of this proceeding. And I was hoping for a confirmation on the record that Ms. Richins is consulted and agrees with that waiver.
I have that.
What the DA just said is, hey, we know that Kouri Richins has previously in writing waived any hearsay objections. When the DA filed their response, they filed like 15 different affidavits and things with their response. We're not going to get into all of that today, but that's why they're like, for the purpose of this hearing, she had waived hearsay objections to all of those affidavits to allow the motion hearing to go forward. So that's what the DA is asking about.
My list. Why don't you keep going through the rest of your 4?
Similarly, a confirmation of consultation and agreement by the defendant that she does not waive attorney-client privilege. I'm here to also confirm the state does not waive hearsay. And I wanted to note for the record that we have added some additional case authority since the original submissions. We have added United States versus Hatcher, that's 323 F3rd 666, an 8th Circuit case from 2003. We provided that case to the defense on July 31, 2024, and we included it in the binder we provided to the court on August 1st.
Right.
Okay. Got it. So as a preliminary procedural note,
The camera is run by local media, KUTV. Is
No
the pool
problem, it
camera.
happens all the time.
The new lawyers are appointed public defenders.
There was a joint request to submit for decision and waiver of hearsay objections that was submitted. It was signed by defense counsel. It stated, among other things, that defendant has waived all hearsay objections in relation to the court's consideration of the motion to disqualify prosecution. I have two questions on that.
Sure.
First, does that specifically include the 18 attachments that are listed?
It's
In
so
the
many
joint
attachments.
request
It should be
is
included.
And did you make that waiver in writing after consulting with Ms. Richins and advising her of the pros and cons of doing this?
We did.
Okay. As part of that, you were also quite clear that Ms. Richins does not waive
Attorney-client privilege.
the attorney-client privilege between herself and former counsel, correct?
That's correct.
And I imagine she was consulted about that as well.
Correct.
All right.
Okay.
And then were you able to review that additional authority that was sent over by the state's office?
We did. I mean, we take issue with the Hutchins case, but we can address that at the appropriate time.
Okay.
The defense said they take issue with the
Ms. Olson,
the added case law.
No, the Hatcher, excuse me, the Hatcher case.
Understood. So we're here on defendant's motion to disqualify the prosecution. The
Who said they
relief
found corpse
requested
husband's day job?
is in order.
Chat. You guys are the absolute best. You're like, yes, this is what corpse husband does when he's not making music or playing games. He is actually this judge in Utah.
Either disqualifying the Summit County Attorney's
I'm
Office
here for it.
as the prosecution in this matter as a whole, or in the alternative, disqualifying Mr. Bloodworth as a prosecutor.
So those are the two things the defense is asking for.
The defense has the burden of production and persuasion on the motion, and they're entitled to the first and last word.
So-
Louis, where do you want to start?
Oh, sorry, Your Honor. That was so rude of me. All right, that's better. Now he looks like John Cena. That's a better pause space. It was so rude before. Please forgive me. And tell me that I've been good. No, I'm not kidding. I'm not even going to say that I'm kidding. So what the judge said is that this is the defense motion. The defense bears the burden of proof. The defense has to show why the entirety of the Summit County DA's office should be essentially yeeted from the case, or specifically Mr. Bloodworth should be yeeted from the case. So he's saying, okay, let's go forward. Defense, it's your motion. Let's go.
Well, Your Honor, I think that our main concern with what has been presented, and as you've already stated on the record, we agree, we waived hearsay and we accept the affidavits that have been submitted by the state.
There were a lot of
in this
affidavits.
case, and by the members of Summit County Attorney's offices, officers of the court. In going through what they have presented thus far, I think the issue that concerns us the most is any finding that there would be a waiver of any privilege knowingly by Mr. Hamady.
And that's the argument that the DAs made, that, hey, by calling in on the, recorded line, you waived. I think the DA's office isn't pushing it. I think the DA's office is like, hey, if you want to fucking fight, I'll fight. But we didn't listen to your calls. We're not doing what we're accused of. It's heavy-handed, but if you want to go there, we'll go there, and we think we're right. So that's what they are talking about with we want to make clear that the attorney didn't waive attorney-client privilege by calling in on the recorded line. That's what they are discussing, because the DA's office threw it out in their opposition and was like, we didn't do anything wrong, but also, Your Honor, here you go.
In phone calls that are at issue in this.
I don't need to go that far, though, to deny the motion.
I think you're absolutely correct. And that's what I just wanted to make clear. Because
Well,
from
Your
our standpoint, you don't need to go that far.
Counsel, I don't need to go that far to deny your motion. She's like, you're right. You don't have to go that far to deny the motion, but we can kind of see where the judge is at.
Is what the state has presented on the record is that what happened is what we expect to happen, especially as defense counsel, when we discover, sometimes inadvertently, sometimes knowingly, that a recorded phone call has been given to the prosecution.
It
And
wasn't.
that is that as soon as the
All the recorded phone calls are given to the prosecution. Every recorded phone call is given to the prosecution. That's why there's an attorney line and a public line. That's like the whole fucking point.
prosecution takes note that that is an attorney-client call, the call is immediately stopped, it's given to a tape team. I know they've represented that that's what's happened.
That's what they said
and
happened.
We don't have any evidence to say otherwise than that.
Right.
So I do believe that
Yes, it was given to a tape team.
That privilege was waived is not relevant to the findings today, but we do think it's important that
I think it's an interesting
addressed,
question of
and
law,
yes, I do
Mr.
think
Bloodworth.
There's another way to reach the issue. And
I
because we certainly would be
like the
concerned
question.
with any kind of finding that there was any waiver.
I also think that Mr. Bloodworth was really happy to be like, oh, you want to fight over what your client said? And this was not this attorney's filing. This attorney didn't file it. This attorney is picking up somebody else's work midstream and going with it. But when the door was kind of opened for Mr. Bloodworth to share some of the things of like, hey, the only reason we know what's going on with the defense is because your client's talking a lot about her lawyers. He went call by call and was like, and in this call, she said this to this person. In that call, she said this to this person. You know, Mr. Bloodworth is like, don't threaten me with a good time. You want me to put in a filing to the court and the public that your client's calling her lead counsel a dumb bitch? I'll absolutely do it, because what client name calls their private counsel in calls that they know are recorded? Come on. Not to mention, Sky fought like hell for this defendant. Oh, so the DA's office was making clear why they knew things that were going on and why they knew that the defense attorney wasn't using the private line is because of Sky running her mouth.
On Mr. Hammondy's part of privilege.
It seems to me that the findings that are supported by the evidence is that there was no intentional or purposeful intrusion into the attorney-client
Well, that's the end of that
relationship
motion.
between Richins and her counsel by the Summit County Attorney's Office or either.
Whoop, there it is. Did you hear the court? That's the judge saying, well, there's that. Based on the evidence, there's nothing. Do you think, chat. No, I meant Kouri was running her mouth, not Sky. If I said Sky, that's not what I meant. I think Sky did a great job. Do we think, chat, allow me wild speculation. Did defense counsel wear what could be argued to be a sky blue suit to stand in solidarity with prior counsel? Just, do you think it was even thought through that much? I don't think it was, but I would love to think that it could be. I would love that. I think it is this attorney just saying, I stand with the sky. Could it be coincidence? Sure. Is it probably coincidence? Sure. But do I love it? I'm here for it. I'm just here for the moment. It's like, oh, you don't want Sky as your attorney? I'm going to show up as Sky Blue attorney. We're going to do that. Just Easter eggs, like just the Easter eggs.
That there was any waiver on Mr. Hammondy's part of privilege.
So the judge.
It seems to me that the findings that are supported by the
The judge is done.
is that there was no intentional or purposeful intrusion into the attorney-client
And
relationship
there it
between
is.
Richins and her counsel by the Summit County Attorney's Office or any agent of it. Do you see any error in that finding?
I don't. No.
And on that basis, I don't see a basis to this.
He asked defense counsel, on this record, I don't see any intrusion into the attorney-client privilege. Do you see any error in that thought process? And the defense attorney said, I don't, Your Honor. This attorney is, again, doing the work that she is left with because somebody else filed this motion. And she's like, yeah, Your Honor, I'm not going to fight you.
Qualify anybody from that office.
So he's not
At
disqualifying
least
anyone.
under this
I should have just let him finish. Sorry, Your Honor.
relationship between Ms. Richins and her counsel by the Summit County Attorney's Office or any agent of it. Do you see any error in that finding?
I don't. No.
And on that basis, I don't see a basis to disqualify anybody from that office,
Yeah, we're done.
at least under this record. I'm not suggesting that the case is frozen in time, but on the record before me today, that is the affidavits and other attachments that are referenced in the joint request regarding which Ms. Richins has waived any hearsay objection. That there is no credible evidence that anybody from the Summit County Attorney's Office listened to any potentially attorney-client privileged phone calls other than to confirm, well, that's Ramsey, I'm moving on.
Whoop, there it
Or
is.
did anything else to intrude upon
Done.
the attorney-client relationship
Yeah, done.
between Ms. Richins and her prior counsel or with any of you. Am I missing anything in the record before the court?
I don't believe you are, Your Honor, and, our only position
Nope, you're not missing
would
anything.
be that, of course, if anything were to come up in the future,
Sure.
that would be something we had addressed at that time. But as of right now, no, I
Done.
think, as the court has articulated it, that's correct.
Done, that's
Is
it.
there anything else you wanted to say at the outset regarding the March interaction
They're going to just sit
between
down.
Ms. Lazaro, jail staff, and the notebook?
I don't think we're in a position to address that, Your Honor, and as we said, Ms. Lazaro is not waiving privilege.
Right.
We weren't present when that happened, so we'll just submit what is, so far in the record on that issue. We should submit on that.
I don't see any legal issue with jail staff reviewing, scanning a notebook
I don't
for
either.
words, diagrams, or contraband that would constitute or implicate.
Right. You can scan for contraband, especially after the defendant is plotting with her mother to bring contraband into the jail. Yes, that contraband is Crest White strips, but in jail, it is still contraband. So the judge is like, the jail's allowed to look through these things. You can't expect them not to, and they don't have to not. So the judge is like, yeah, we're just, no. They didn't do anything wrong. The DAs didn't do anything wrong. Can we all just move forward?
A safety concern.
We would agree with that. I know that in the motion filed by Ray Quinny has intimated that it went farther than that, but yes, as you said, we don't have any affidavits to support that, and we're not waiving privilege, and there's no one here to testify about that. But yes, I do believe they have the right to scan briefly any documents coming out of the jail.
Oh, Kouri.
All right, I'll make sure.
Kouri, this attorney is not going to argue with the jail staff maybe the way your prior attorney was going to. And she's definitely not going to be sneaking you in Crest White strips because she's like, yes, Your Honor, I agree. The jail has the right to do that. Because that's like what the law is.
His last word. Ms. Olson, Mr. Bloodrow.
Oh, the camera work.
Thank you, Judge. We took the liberty of preparing what we consider to be a robust proposed form of order.
I looked at it.
I would like to speak to you about why I think the scope.
This is the elected DA. First of all, I have tremendous respect when the elected DA goes to court, right? Not all elected officials do that. Some elected DAs have never even, been to court or done a trial. Most places, it's line DAs who did the job, who the community respects, become the elected DAs. But anyway, when you get an elected DA trying a case, going into court, arguing the motions, and standing up for their line DAs, I respect it. So I am interested to see, this DA brought a whole fucking binder with tabs, and she's like, I need to talk to you, Your Honor, because I need to put some shit on the record. I'm here for it. What, ma'am, what would you like to say?
That order is so important. As a criminal justice professional for 3+ decades, I have observed a certain practice creep into the conduct of some defense lawyers.
Oh, she's
That
big
is
bad.
intentionally placing appellate issues into a case. So if their client is convicted, they have a good shot at the second trial. Let's call this the poisonous breadcrumb strategy. I am one member of the bar who strongly disagrees with that conduct.
Oh boy.
I posit that every lawyer has an affirmative duty not to engage in conduct that would be prejudicial to the administration of justice. And for this, I cite Rule 8.4D. It is wrong for a lawyer to intentionally throw a wrench into the gears of the system of justice, to intentionally create error, to intentionally procure a fundamentally flawed proceeding for their client.
Oh boy.
As an elected county attorney, I have a sworn duty to protect the constitutional rights of the criminally accused. I have a duty to provide a fundamentally fair process. Among
true.
the many rights of the criminally accused, I am charged with protecting the right to a manufactured appellate issue is not one of them.
Mad.
Ray Quinney and Nebaker and Sky Lazaro went where no attorney has ever gone.
Ma'am, I get that you're big mad. She is big mad. And she is saying that she is going off on the previous defense attorneys and saying that they are leaving, she called it poisonous breadcrumbs, that they are poisoning the case and creating issues as a part of the defense strategy. My only distraction in this is that I know that the flaps of the back of the suit are stitched and that stitching is meant to be cut. So my neurodivergent brain is sitting here going, but you didn't cut the strings off the flap in the back of the jacket. Can we do that? Because it frustrates me. But go off, ma'am. You're absolutely right. And she's about to go off about what the previous defense attorneys were doing. And I want to hear what she has to say. She says, I do not have to protect somebody's right to a manufactured appellate issue.
Issue is not one of them. Ray Quinney and Nebaker and Sky Lazaro went where no attorney has ever gone before
Space?
and took the unprecedented action of seeking.
Went where no defense attorney has ever gone before.
Ray Quinney and Nebaker and Sky Lazaro went where no attorney has ever gone before and took the unprecedented action of seeking to deprive this aggravated murder proceeding of every single attorney of record on a single Friday afternoon. They withdrew and they moved to disqualify the entire prosecution.
Wow.
So this is where I need you to slip in for a second.
They did do that. They dropped grenades into this case and then walked away. They did do that.
Sky Lazaro's motion to withdraw was not because of any of her conduct. It was an imputed conflict from somebody else in a large firm. And so I need you to
We
stop
don't know
just short of going too much farther down the road of
Admirable, Your Honor.
alleging a dial and dash kind of plan here. Let's just stay focused on what was in the motion and what evidence there is, if any. Why do I need
I
to
appreciate
make findings
that the judge
regarding the
stopped
content
her
and
short of
circumstances of communications
shitting on
that
everybody?
your office hasn't listened to?
Because
He believes the DA's office. He's saying, your office hasn't listened to these. I believe you. He goes, but there are bigger issues of why Sky had to leave. And that doesn't have to do with anything that she did. It has to do with conflict from a larger firm. So he put enough on the record to say that she's not throwing a grenade into this case and running away from the blast. What he's saying is she had to because of other issues. And I need you to stop short of getting into this Because again, Sky Lazzaro's not there to defend herself. So she's off the case, and the court, I think, is saying, you're mad, but let's tone it down. Let's just a little bit.
The motion sitting in that record, if not addressed now, if not addressed thoroughly and cleaned up now, is the equivalent of an undetonated grenade in this record.
Hey, I was
I
just using that
respectfully
analogy. Ma'am, DAs are on the same page. She's just saying it's she's like, the pin hasn't been pulled yet. It's just sitting there waiting.
Of an undetonated grenade in this record.
I respectfully disagree if the court finds there was no Sixth Amendment violation because
The
there
court's
was
ruling.
no intrusion
Right.
into the attorney-client relationship. And there cannot be any intrusion under the evidence in the record before this court.
Yeah, the
It
court's
simply
denying
didn't
this motion.
happen.
Yeah, the court's denying
Regardless of what Ramzi Hamidi did or didn't say, or what Ms. Richins objectively or subjectively believes the circumstances of that call were with respect to confidentiality, the evidence showed Mr. Bloodworth didn't listen to him, and that jail staff did not read the substance of that notebook.
Okay.
That's it. I can understand why your office is really pissed about the content of that motion, but that is not enough to form a Sixth Amendment.
He's wiggling. He's like, that is
It's
not
not.
enough. Oh, Your Honor, you must be a lot of fun to practice in front of. But he's like, no, look, I'm ruling in your favor. This is what he's trying to sell to the DA. I get that you're pissed, but if I rule in your favor, then there's not an issue here. And I'm basically telling you that I'm ruling in your favor. So I'm going to need you to tone it down and let's just get through this. But he's just like, it's not going to be a problem. I get why you're big mad, but I got you. It's okay.
There's no factual basis, there's no legal basis, and it was done for an improper purpose. And while those unfounded allegations are of the utmost concern to this team, protecting this record is our primary goal. And
Your
I
Honor, she
believe
called
that
us out of our
this is
names.
what Your Honor needs to do. We have thought long and hard about this.
Sky talked big shit about us.
It has been a real burden to try to work through this with this sitting unresolved in our record. And I agree, correcting the record begins and ends with one simple and essential truth. We didn't listen to the calls.
And did not
And he said that.
read
He says he found
contents of
that.
the notebook that was alleged to be attorney-client privileged notes from Ms. Richins to her lawyer at the time. Right, we can acknowledge that
She's
if that
not
had
done.
occurred,
She's not done.
if that had occurred, we'd be having a different conversation. There's no evidence that occurred. And there's no objection from the defense to reasonable scanning of documents going out of the jail to make sure they do not contain safety concerns or contraband. You're right on the law on that.
You're right on the
Judge,
law.
I'm accountable to this community. The community, Eric Richins' family, and the defendant deserve to know with certainty that there has been no intrusion
And he
into
said
the
that
attorney-client relationship.
twice.
I believe the proposed findings of fact and conclusions of law that we've submitted to the court.
She's asking the court to make specific findings of fact, which he's making a record of. But she's asking the court to make specific findings of fact that what they were accused of did not happen. She is offended on behalf of her office that they are being accused of playing super dirty. And she's like, we would not, did not, would never. And we are asking you to make findings on the record that we did not do all the shit that they threw into this motion. But the judges said it like 3 times.
One second.
He said over and over, look, I don't think on this record there's anything that shows that your office did what you're being accused of.
Keep going. You are accountable, as am I, And Ms. Nestor, Ms. Lewis, and Mr. Ramos are accountable to me and to the bar. We are all accountable to somebody here. There is no credible evidence
There is
of
no
any intrusion by
evidence.
your office or anybody in it or any agent of it
Get in the
into
car.
the attorney-client relationship between Ms. Richins and her
And he is
current
making a
former
record.
counsel.
There you go.
That is the end of the motion.
May I recite a few?
No, ma'am, I have said for the fourth time, counsel, that there is no evidence that your office did anything wrong. Ma'am, we're good. We're good. I know you're mad, but the court's on your side. When the court's on your side, it's time to sit down.
Names I would like to see in the order.
I've read them, but you can if you'd like.
She's going to put them on the record anyway. He's like, I want to do this. And he's like, I read them, but if you need to put them on the record, you need to put them on the record. Go right ahead. She's like, I put on a suit and came to court for this. I'm the elected official. So he's like, go ahead and make your record.
Ms. Richins and Mr. Hamady knew their calls were being recorded.
Yes.
Because the recordings existed, their production and discovery was compelled. Just because the recordings exist does not mean anybody listens to them.
He said that 4
For the
times.
reasons, and I thank you for the
Correct.
reasons you said.
His voice is delightful. How are you not listening to him? I have listened to judges that sound like nails on a chalkboard. He is a delight. He said it at least 4 times that on this record, there is no evidence that your office listened to any of those calls.
The prosecution did not listen to them and diligently sidestepped them.
We did not listen to them
The
on a plane. We
allegations
did not listen
By
to them
Ray
on a
Nevercurd
train.
and Sky Lazaro are speculative at best and bad faith at worst.
We did not listen to them on a
The
tree. We did not
conspiracy
listen to them with our knee.
Joe
We did not
Purcell
listen.
intruding into
Sam,
the
I am.
attorney-client relationship and sharing information with the prosecution is speculative at best and bad faith at worst. There has been no per se Sixth Amendment violation. The 34 calls are not
Yes,
protected
ma'am.
communications. I want to go there. The presence of a recording device destroyed any privilege that may otherwise have existed. There
He's
was
not
no
finding
intrusion
that.
into the attorney-client relationship. The prosecution never became privy to any attorney-client communications. And the timing of the motion to disqualify, 5 months after Ray Quinning and Nevercurd discovered the existence of the 34 recordings in the discovery file, 5 months after the email.
Your Honor, the timing
contained
is sus.
swift and categorical assurances by myself and the chief
She's just
prosecutor that
pointing
no such intrusion
with her
had
pocket.
occurred. And 3 months after the disturbance at the jail is a standalone basis for denial.
He's already told you he's denying
Because of
it.
the timing and because it can be viewed as a manipulative litigation tactic under the.
You've made your record. You've made a
TJ
written record. The
investment
judge is like, we could have been done by now. I've told you
I
4
would like those
times.
findings, Judge, and I think the rub
He
between
said he's,
myself and Ms. Lewis is simply that finding that, and it's the.
when you're winning, stop talking. He said that you were winning.
It's the new case.
You're asking the court to rule as a matter of law that any communication made by Ms. Richins to her counsel outside of the protected arm of the home wave system is automatically a
Yeah, and he's not going to go that
non-confidential
far.
communication. I'm
He's not going to go
prepared
that far.
do
No,
that.
he's like, don't push me that far.
And I don't need to,
No, you don't.
because the evidence shows your office did not listen to it.
Right.
Which was the correct response. And so we don't need to go down that law. The implications of that broader ruling might
We
be
don't need to get
difficult
to.
for you to see around those corners at this point. I'm not doing that though.
He's like, right, we're not doing
And I
this.
do need to place on the record another thing.
What?
After this defense team was.
It's better be
appointed,
tea.
They asked that if we would cause the taint attorney to remove those 34 calls from the discovery file, and he did do so, and he is in sole possession of.
Your Honor, the taint took care of it. So I'm going to stop waving my finger around in court and sit down. She said that the new defense team asked that the taint attorney remove the 34 calls where the defendant and her attorney talked on the recorded jail line because her attorney didn't want to call in on the other line. And those have been removed from the discovery files. And then they are held with the taint attorney in case they are needed for the appellate court or whatever. So, ma'am, this was all in your writing.
Both. I wanted to make that clear.
Okay, it's clear. Great. Good job. Well done, ma'am. You can sit down.
Okay, that's my request. I'll wait and see what your order says.
I understand. Anything else?
No, Your Honor.
Okay.
Your Honor, I really want you to
Ms.
put it in
Lewis.
writing. No.
Your Honor, I don't think we have anything to add. I mean, you addressed our concern. So unless you want me to say anything more about the waiver of privilege, we don't have anything to add. We just submit.
Okay.
The new defense attorney's like, thanks, Your Honor, we're good. We could have been gone 10 minutes ago.
The issue
We're
before
done.
the court is defendant's motion to disqualify the prosecution.
He's like, denied.
And requested in order either disqualifying the Suffolk County Attorney's Office in whole or disqualifying Mr. Bloodworth as a
Oh,
prosecutor.
and now we've got glasses on.
The factual allegations on which defendant's motion is based are twofold. First, that Mr. Bloodworth listened to certain attorney-client privilege communications between defendant and one of her attorneys, or prior attorneys, Mr. Ramzi Hamidi. There's no credible evidence that Mr. Bloodworth or any other agent of the state has listened to any attorney-client privilege communication between defendant and her counsel, other than a few occasions on which Mr. Bloodworth listened to the minimal amount of time necessary to identify
That the attorney was on the
Mr.
other line.
Hamidi as a participant in
Right.
the call, and after which Mr. Bloodworth promptly stopped listening and moved on. The second factual allegation upon which defendant's motion is based is an incident on March 26, 2024, during which jail staff, specifically Sergeant Thomas, would not allow defendant to pass a notebook to her counsel, prior counsel, Ms. Lazaro, until after jail staff had read each page of the notebook. And there's no credible evidence that Sergeant Thomas did or even attempted to read the substance of any page of the notebook, as opposed to merely scanning the pages for words, diagrams, or contraband that implicated a safety concern for the jail or jail staff. Based upon an independent review of the record, the court finds that neither Mr. Bloodworth nor any other agent of the Summit County Attorney's Office has intentionally or purposefully intruded upon the attorney-client relationship between defendant and her counsel. And the Summit County Attorney's Office has not directed the Summit County jail staff regarding the conditions of defendant's pretrial detention. Based on those findings, the court concludes that no per se violation of defendant's Sixth Amendment rights has occurred based on the conduct of the Summit County Attorney's Office. And based on the record before the court, disqualification of Mr. Bloodworth or any other attorney in the Summit County Attorney's Office is not necessary to maintain the fairness of these adversary proceedings.
There we go.
In sum, defendant's motion to disqualify is without credible basis and is denied.
That's a pretty strong denial.
The
He
court
didn't
will
just
issue
deny
written
it.
findings.
Hold on. He didn't just deny it. He said it is without a credible basis. So the judge didn't go as far as the DA wanted, but he did go pretty far saying this motion has no credible basis. And that's a pretty strong ruling on the defense motion. This is not just denied. This is there's no there, stop it. So I appreciate it.
Findings of fact and conclusions of law to preserve an appellate record and will issue that written ruling in the near future.
That's it. Okay, thanks, Your Honor.
Ms. Lewis, anything else on the motion?
No, Your Honor.
Ms. Olson,
He's like, you're done, right?
we have a preliminary hearing coming up.
We
At
do.
the last scheduling conference, I asked you whether there were any evidentiary issues or stipulations that we needed to address in advance of that. Have we made any progress, Ms. Olson?
Well, as Ms. Lewis said, Ms. Nestor's been in trial. We are going to be working on that and fully anticipate we'll be able to have it defined prior to the beginning of prelim, so you're on the news.
Okay.
If we have a discussion, I'd like to have it prior to August 26th, so that neither side has any surprises the morning of. And so if I need to fit you into my schedule during the week of August 19th, let me know.
Understood.
Okay.
Okay.
Thanks, Your
Ms.
Honor.
Richins, barring that, I will see you again on the morning of August 26th. I wish you the very best of luck. Okay. Court's in recess. Thank you, folks.
Thanks, Your Honor. And with that, everyone is leaving court. The defendant is leaving. I saw a lot of you ask if the defendant's in custody, out of custody. Is she chewing gum? Who gave the defendant in custody gum in court? Huh. This defendant is in custody. Looked like she had gum. They will be leaving court. The preliminary hearing is set for the end of August. It is set for 3 full days. The court did not allow streaming today. I hope that the court will rethink and allow streaming for the preliminary hearing. But this court at the beginning was just like, I'm not granting this motion. From the earliest possible moments of this hearing, this court was like, I'm not granting this motion. This isn't happening. Oh, chat, you're right. Maybe her attorneys brought her some whitening gum to court for her before she went back to custody. But that was the hearing on the motion to dismiss the entire district attorney's office. The elected DA was mad and was like, Your Honor, I have an obligation. And I am going to tell you, I am offended. These defense attorneys are laying poisoned breadcrumbs, and I am not having it. I am done. So, in summary, this hearing would have been a lot shorter if the DA didn't need to make a record about how pissed she was, something that was acknowledged by the judge when the judge said, I can understand why you're pissed. But the court ruled in favor of the district attorney's office, denied the defense motion to yeet the entire DA's office and yeet Mr. Bloodworth, the DA. This case is getting ready for preliminary hearing in Utah. They say it's going to take 3 days. I don't know why, but they say it's going to take 3 days of preliminary hearing, probably to go over all the financial records. So it's going to feel like a mini trial with no jury. The rules of evidence aren't quite as finite. You can have evidence that is hearsay when offered by law enforcement and things like that at preliminary hearing. But I wonder if they're going to bring in quite a few percipient witnesses. They did that for the bail hearing, which if you have not watched other coverage of the Kouri Richins case, there is a playlist for you. The walk the dog letter and the bail hearing will get you all caught up to speed. But if you want the tea and me reading dramatically her jail calls, that is in some of my other coverage of this case. Not a lot has happened since her attorneys left. This was the big motion that was pending before the preliminary hearing starts, and we know that it's been denied. And this will move to preliminary hearing, and then it will probably be about a year after preliminary hearing before we get to trial. If not, I'm hard pressed to say it would be less than that. I think probably about a year after preliminary hearing to get to trial. Could be faster, but I wouldn't hold my breath on that. We're going to do some questions real quick, and then remember, we're back here tomorrow for the Karen Reed hearing out in Massachusetts. For all of you in the chat that were like, Emily, you are standing this judge so hard. We spent 10 weeks in Massachusetts with Judge Cannoni. Yes. I really like this judge. He's clear. He's linear. He's organized. He looks at the attorneys and is like, are you done? Gives them an opportunity to make their record, signals to them that it's time to dial it back a notch, stops them when they're getting too hyperbolic, but letting them know that's going a bit too far and redirecting, as opposed to saying, I don't like those words. You know, I don't like that. I appreciate this judge quite a lot. I've liked him since the beginning of the case. He lets the attorneys be heard, but does not let them run amok. And that is a welcomed balance in a case, and I appreciate it. So thank you, Your Honor. We appreciate you signed sincerely, the Lawnards. Now, if somebody could file a motion titled "Get in the Car, Elizabeth," that would just 10 out of 10. 10 out of 10. God, if the Walk the Dog letter was retitled. Damn it. Missed opportunity on the Walk the Dog letter there. But I guess the defendant was really focused on her own case, maybe, and not other cases and other defendants. Do you think Kouri Richins is pissed about how much attention Karen Reed gets? Do you think she's looking on the internet? I don't know how she would do that. Do you think she's asking, like, when they're talking about KR, are they talking about me? And her family's like, no, they're not. They're talking about that woman in Massachusetts. Are they talking about my hair? No. Also the woman in Massachusetts. Do you think she's mad? I think she's probably mad. So with all of that, tomorrow we will be back in court in Massachusetts. Make sure you have the Lawnard app. Do the YouTube things here. Like the video, subscribe to the channel, join the membership, whatever you want to do. All right, we're going to answer a few questions and then we are going to boogie yogi because I'm late. Emily, are you always late? Yes. Is that just part of life at this point? Also, yes. Do people forgive me? Most of the time. I try to give a heads up. CW said, does Kouri have public defenders now? Yes, she has court-appointed counsel. I don't know if they're public defenders or alternate public defenders, but yes, she has court-appointed counsel. I think they're with the public defender's office. I need to check the last filing. Missy said 15 months of coffee and cursey words. Thanks, CDB. You're welcome. I know our normal 11 a.m. time frame gives us time for that. So Colin said, this is fair use. All I'm doing is screaming. Exactly right. That's exactly right. And that's my fair use on water polo. Wendy asked, Emily, what position did you play in water polo? I was mostly a whole guard, but I also did some driving and then some wing. It just depended. It depended on at what point I was playing and who else on my team was in, and also I'm short. So I'm short but tough. Mon Bet said, how I love you, Emily. Thank you. You are welcome and I appreciate it. It's good to see everybody and thank you for your super chats. I appreciate it. So live stream well at the gym. Love this. Thank you. Appreciate it. 18 times fun when you're having time flies, Kermit. 18 months. Yes, Lucy, it has been 18 months. It's wild. You're not the only one. Veronica said 18 months. Where did the time go? To lots and lots of court cases. We have been very busy. We have been in trial and then we were in trial and then we were in more trial. Lucy, thank you for the gifted memberships. I appreciate it. G. Lander said, in my best Ron White voice, KR has the right to remain silent, but she doesn't have the ability. She does not. She wants to be heard by her lawyers, by the media. She just wants to talk about all of the things. Jen said, Emily, did you see Carrie submitted a new filing about Alec Baldwin and Rust? I covered that on Tuesday. So yes, we covered it. Tuesday was the new filing. So there's not been anything since Tuesday. So yes, I did. Hey, EDB fellow Lawnards, happy to be here. Me too. And that stream was long because I read all of it because Carrie was just wildin'. Sky Blue attorney says, all good, thanks. Yeah, the new defense attorney is like, yeah, we're just walking the dog on this one, Your Honor. The other attorney filed it and we're good. Casey Cat said, I would very much like the judge to record, I'm sorry, it's time to wake up, my darling, for my alarm, even if I just roll over to the cats. Yes, we also need him. I have a list. Your Honor, the book talk side of the Law Nerd chat has suggestions. Karen asked, is this an election year? I don't know if it's an election year for this DA. I don't know. The judge oh my God, the judge, is this a long story? Yeah, the judge was like, the judge was literally looking at the DA like, you're already winning, but if you must. He was very patient and the DA is like, we have time. And when it's the elected DA, I think it's a little bit different. You've got to be like, Go ahead and jump through your hoops. That's fine. Sarah JD said not EDB fangirling over the judge, excessive fangirling. Well, no, I think it's actually reasoned fangirling after some of the cases that we've watched. I think it's reasoned. Music to My Soul said, Your Honor, the defense lawyers laid poisonous breadcrumbs and my prosecutors are innocent Hansel and Gretel. Yes, Mr. Bloodworth is unfortunately, Mr. Bloodworth sitting in court like this. He's just like, tell me again how you called your attorney a dumb bitch. He's just not, he gives the Bloodworth of it all. I'm waiting for him to turn into like the Count and being like, how many times did you talk on the jail calls? 1 jail call, 2 jail calls. That's what I'm waiting for from Mr. Bloodworth. No, I'm sure he's lovely, but his last name is Bloodworth and he just sits in court and is like, and I can't. This trial is going to be so interesting. Haley gifted 5 memberships. Thank you and welcome to the new Lawnards. New Lawnards. Canonical. I tried to say it right. Some days my mouth doesn't cooperate. Said, hey, it's been a minute. Lovely to catch you live. It's good to see you too. Happy to have you in the chat. Motion for the judge to say good girl just once, right? But he did look at Miss Richins and was like, I wish you all the best. How do you think do you think she's sitting there going, He's just a delight. We love you, Judge. Appropriate. What time are we boarding EDB Airlines tomorrow for Massachusetts? I believe we will be boarding right before, I think boarding will start at 12:45 p.m. Central. The hearing is at 2, I believe. So should start right around 1 and we will be there tomorrow. We're going to have a lot of pissed attorneys tomorrow, aren't we? Tomorrow's going to be a good day in court. I'm here for it. Who knows how much commentary we'll give. I'll just be sitting here going, go off then. I'm ready. Came for Tati, stayed for JD. Flightless, thank you for still being here 24 months later. We're starting to see a wrap up of the 2020 cases that I covered. Tati is wrapped up. We've got finally now closure, it seems, on the Haley Page case that's settled. We've got Tom Girardi going to his first criminal trial with all of the witnesses we saw. So it's going to be really interesting. For those of you asking, will AJ be back in court tomorrow? I don't know if he'll be back in court. I can only imagine that he will be, but we'll see if he's the one arguing the motion or not. I don't know, but we'll find out tomorrow, won't we? I'm interested to see. So Lawnards, I hate to cut the live short at like an hour and a half, but I absolutely have to scoot because I've got to go. I got to go do volunteer things. So tomorrow we will be back in court. Thank you everybody for hanging as we were waiting for the feed, as we were waiting for the court feed, and I appreciate it. So thank you guys so much. Thank you for being here. And again, thank you for being a Lawnard. Are you ready to ride tomorrow? I am ready. Look, we did a late ride today. It's going to bridge the gap between tomorrow. You know, go check your Animal Crossing island. Check in on all of your gaming, your Stardew Valley. Go do the things you need to do so we are ready for court tomorrow. And if you need to body double with me tomorrow, make your to-do list right now and then just body double with me tomorrow. We'll be back here in like 12 hours or whatever. So I will see you tomorrow. Get the Lawnard app and do the YouTube things. Have a fantastic night. Appreciate you mods. Thank you for being here. Thank you everybody for being patient as we waited for the feed. And, you know, Lawnards, let's roll. We've got another court tomorrow. So I'll see you then. Take care of yourselves tonight. I'll see you tomorrow.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnardapp.com. or search the App Store for Lawnard. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Lawnard.